is underutilized. I mean, that would, you know, keep spheres of practice for a lot of lawyers, but that's really underused. So I think it is time for a full discussion and a debate, and it has to include the membership. A small issue is I am a sitting bencher, and around the table, even in a small way, only about 4 benchers out of all the benchers who attend, the 40 plus, only 4 benchers you know, come with using their iPads or their laptops, and so it will be, I think, a matter of, you know, people being dragged and screaming and kicking into what really is happening, what diversity is causing to happen, and globalization for the practice of law in Ontario. So I think you know, excellent. You know, we do need a full discussion and debate. Thank you.
Thank you, Susan. And I'll turn it over to Monica Goyal.
Thank you, Glenn. You know, the terms like e-lawyering, virtual lawyering, cloud technology, outsourcing, I think those types of words have been absent in this current bencher election campaign, and it's disheartening, because I think in the next 3 to 5 years there's going to be a real shift in the practice of law, and we're seeing that in the U.S. So at this legal IT conference, we had the speaker who spoke at the beginning has a practice called direct law, and he provides lawyers, helps lawyers set up an e-lawyering presence and e-lawyering practice online. And they're starting to feel the impact of, in the U.S., of LegalZoom and the likes of LegalZoom, and it is kind of chipping away, or as he described it, chipping away at what would be traditionally done by lawyers. That is threatening, and that is scary, and you can't just deal with it at the last minute. I think it needs to be talked about, discussed now, and we may have to reinvent ourselves, but we need to be prepared, and we need to, I think, you know, do our due diligence around these issues. And that's it, Glenn.
Thanks, Monica. And Catherine McKenna, can you tell us your thoughts?
To be honest, I mean, this isn't really my issue in that, I mean, certainly technology, a wave of the future. Canadian Lawyers Abroad wouldn't exist without technology. We deal with our partners overseas through Skype, through the internet. We use Twitter, Facebook, blogs. So, I mean, certainly it's important. In terms of articling, I mean, I think it probably means that there'll be less positions. That as you see some outsourcing, including to India, according to The Economist, I mean, there's going to be less positions available, and I think technology is an opportunity. So when people are very concerned about articling and how will students, how will we train new lawyers, I mean, there's ways of doing things online, and I know the Law Society and other organizations have CLA material online, and I think there's a lot of opportunities there, and that's good for people that, for example, might have children and have are trying to balance, as Omar said, their life with the requirements of being a lawyer.
Thank you. And Omar Hare.
I think what I was going to say pretty much covered there by the previous speaker, so in the interest of time, I'll pass it on.
All right. We do have a question from the audience. It's one submitted by B. Mavison. So I'll throw it out there and throw it out there for each of the speakers to respond to. He notes that the Law Society in the last couple of years has had a very in-depth review of articling with multiple different options for a different requirement and decided to maintain the current system nevertheless. On top of that, there's very little appetite for increasing Law Society fees even higher. So with that in mind, what are you going to do to increase articling spots? And given that that's something directed for the candidates themselves, I'll ask that just of the candidates. And start with Hare.
Are you calling Ms. Hare?
Yes.
Yes. Okay. I'm sorry. I just missed that. Yeah, there has. I've been on convocation, and we did have discussions on articling over the past term, and I think probably they've had the same discussions, you know, for I don't know, last 50 years or however long they've been there. And the general view was that articling is a necessary rite of passage for the profession to be able to say, you know, I can actually combine theory from law school with practical legal problems on the ground and go forward with it. I don't think I'm too off in rephrasing the general feeling. People felt that it was benchers felt that it was important to keep articling, and they have urged, I guess, smaller changes in terms of assisting people who are not able to get articling, which is usually primarily you know, racialized minorities and Aboriginal people and mature students. So there has been that discussion, and I think though too there's a you know, there's different parties that are can be involved in coming to a solution. I think lawyers in general have to step up to the bar and say, okay, you know, we have never taken articling students before, and you know, we'll try. We'll take an articling student on, and because there's many firms and small practitioners and small firms and sole practitioners who have not taken on law students, articling students, and that's it's really too bad. So I think that, and I think too, students have to reach out a little more to outside of Toronto. I received a resume book, and I've only gone about halfway through, but people seem to just want positions in Toronto, and you know, it's understandable, that's where their family is. But I think there's different parties that have to step up to the plate, and I think more lawyers in Ontario have to step up to the plate. I think that's part of the solution. I mean, I'm a sole practitioner. I can, you know, and finances, of course, are a concern for every firm. But you know, if sole practitioners can do it, I think the larger firms can do more. And I think articling has to be continued to be discussed. I found my articling experience to be very valuable. I was able to do a lot in my articling with the firm in Sudbury, and they let me go to court, they let me do bail hearings, they let me do whatever I needed to do, go to tribunals. So I think it made me better prepared when I started my own practice, because I started out as a sole practitioner. So the articling experience for me certainly was I think needed and beneficial to my practice. So, but I think that, you know, when we have these, you know, bright, young, trained lawyers ready to go out in the world and address the legal issues of all kinds of people in Ontario, we really shouldn't be letting them down, and we have to keep on looking at innovative ways to get them positions. And as I stated earlier, one of the things I was pleased about was the resume books that the law schools are starting to send out to firms. I believe the University of Ottawa has one, and another law school has one. I forget the name of the third law school. So, you know, the law schools seem to be stepping up to the plate. We'll see if, you know, lawyers in general step up to the plate in Ontario, and, you know, I certainly encourage that. Thank you. Those are my comments.
Thank you, Susan. And I'll turn it over to Monica Goyal.
Thank you, Glenn. I agree with what everyone has said so far. I just wanted to add and build upon what Omar had said about the way people were treated during articles. I had a very good experience, articling experience, but I also had heard very traumatic stories of people while they were articling. I think that's you know, we have the issue where there's a gap in the number of people who are getting articling positions, and then on top of it we have a situation where a number of people are in situations where they're working you know, a lot of like hours, or they're in a situation where the person, their mentor or their principal, is abusive to them, and so I think that's, you know, should also be factored into, you know, when we talk about the articling program, we should also be talking about how do we have like a valuable work experience. Are we just doing the articles for the sake of, you know, meeting this requirement, or are we actually, you know, fulfilling the, you know, mandate of building skills, valuable skills? So anyways, those are my thoughts on it.
And thank you, Monica. And I'll now turn it over to Mitch Kowalski to answer the question of what you do in order to increase articling spots.
Sure. Thanks. Just on the question of Law Society fees, one of my platforms was to freeze Law Society fees for the next 4 years and make the Law Society live within its means. So this wouldn't be a cost issue for me. I mean, the Law Society, if it's going to set rules for how people are going to become lawyers in this province, they have an obligation to allow people to meet those rules. You can't set up a rule and then throw up your hands and say, oh, well, I guess you didn't find an articling position, too bad for you. It's ridiculous. I agree with Catherine that we have to look at whether articling really is an unreasonable barrier to practice. So let me throw something out to you that I've thought about. Is my dad used to practice law. He's been gone for 10 years, so I can't really ask him now, unfortunately. But one of the things that I remember was that when he went to law school, and it was at Osgoode Hall downtown at that time, was they worked half the day at a law firm and they went to school for half the day. So it was a mini co-op kind of program. And if you compressed articling into that kind of co-op situation where you went to law school in the morning and then you went to the law firm in the afternoon, or vice versa, then you get away from the problems that you have now where people don't have articling positions. And then you get away from the gaming that happens, because part of the problem with articling is that you're not really applying for articling position. You're applying for a full-time position to practice law thereafter. So everything gets pushed back in time. And I think the preference would be to, if articling is felt to be important, that you make it just a co-op program where people are not applying for articling so that they can get a full-time job. It's just part of going to school. I guess the other thing I'd like to see is, with respect to